The Department of Justice and Constitutional Development will give an update on the progress made on the Marikana related litigations. Let's take you there live now.
As you would recall, we did give a detailed feedback last year, and there is a reason why we gave a detailed feedback last year. Primarily, it was because previously this office, the Office of the Solicitor General, is a new office. And as you would know, state attorneys themselves are prohibited from engaging with the public, cannot enunciate public or government policy in terms of the operating procedures. However, it is a different aspect altogether with the Office of the Solicitor General, because that office is able to talk to the issues. And we did report last year specifically to debunk the narrative that government has not been doing anything for the past 9 years in relation to these matters or settlement in these matters. The narrative has been that government has just been sitting and not doing anything. So I'm not going to, in fact, revisit the issues that we have advised you or reported on last year, unless if there is a specific question in relation thereto. And to the extent that perhaps there could be issues arising that I might not be able to deal with, I think my colleagues that are with me here will be able to advise us. As we undertook in 2021, our resolve has been that we need to, in fact, deal with all the remaining matters pertaining to litigation as arising from the Marikana incident. And true to our word, we have, in fact, been engaging with our counterparts, the attorneys representing the injured and those that, in fact, might actually have preferred a claim on malicious prosecution against the state. And that process has been embarked immediately after we, in fact, had the press conference last year. We went through what we call a court-sanctioned case management system, where the Deputy Judge President for the High Court in Pretoria was presiding over the issues. And those case management meetings for all the remaining matters were conducted with the Deputy Judge President as the presiding officer, together with everybody else that was representing the claimants. As I stand here today, there were 48 matters that were remaining, but none of those matters related to loss of support due to the death of any other person that has preferred a claim against the state, because all of those matters have been dealt with as at August 2021. The 48 matters that I'm referring to now would relate in the main to matters where there were personal injuries, where people had to be sent for medical examination, actuarial calculations, and so on and so forth. I'm also to announce today that all of those matters were set down by the High Court in Pretoria, and the directive was that all of those matters should either be settled, or alternatively they will have to serve before court before the end of August this year. So as we speak, and as my colleagues sit here right now, our other colleagues are in court as we speak right now. And as part of the report, even without individualizing the matters, half of those 48 matters have already been settled. The other matters, as we sit right now, are actually still undergoing discussions between the parties, meaning representatives of the state and representatives of the claimants are, as we speak right now, in court trying to reach some sort of settlement, or alternatively indicating to the Deputy Judge President that there is no agreement, in which case the matter will then actually be allocated to a judge for finality. However, the days that have been set do not go beyond the month of August. It is regrettable that, in fact, we could still sit and stand here and talk about matters that, in fact, had occurred 10 years ago. As I've already alluded, state attorneys themselves do not have a right to be able to come out in the public and say this is what we are doing, because they are bound by ethical rules that bind all the attorneys. And to do otherwise will, in fact, open themselves up to misconduct charges by the Legal Practice Council. But I can, in fact, give you that update. And I can indicate that it is an instruction that I've given to the Office of State Attorney that all of these matters must in fact be finalized. We cannot actually live forever and have any matter that is remaining. And I can also give the assurance that to the extent that is possible, we could in fact be in a position to resolve all of those matters within this month. I say that it is regrettable that these matters have in fact gone this far. And this is owing to a number of factors, amongst which was there was never any policy applicable within the state which will compel the state to embark on early settlement of matters, be it via mediation or arbitration. And I need to indicate that delays such as have been occasioned in these matters will be a thing of the past, because we have, or the Office of the Solicitor General has already developed a policy that is binding within state departments for early settlement of matters, and that policy has been approved by Cabinet on the 9th of November 2021. We will be presenting that policy before Parliament for noting. Over and above that, we have developed other policies that will in fact obviate having to deal with matters of this nature, the delays that are inherent when you are litigating against the state. And those policies will, in fact, deal with how you initiate, how you defend, and how you oppose a matter. And that is to those that consume state legal services. Again, there is another policy that talks about coordination and management of all litigation in which the state, which is also a new policy that we are coming up with. And it is not so much triggered by the Marikana incident, but matters such as these should not be delayed inordinately. They need to be dealt with at the earliest opportunity. In that way, we are able to, in fact, look at matters of this nature, such as delict, service delivery issues that actually makes the state liable, to be dealt with at an earliest opportunity. And so there would be, going forward, about 5 policies that will, in fact, be geared towards dealing with matters of this nature. Given the fact that the 48 matters are before court as I speak right now, I cannot actually give you more information, because that is what is called contrived, when you don't actually respect the court. It's in fact a situation that in fact cannot be dealt with. Matters are sub judice. And for that reason, you cannot be in contrived contempt of the court process. But I think once all the matters have been finalized, on the last day that the court has actually scheduled, we will be able, via the GCIS, to issue out a statement of where we stand with the litigation in relation to the Marikana matters, more particularly. Thank you very much.
Thank you, Solicitor General. We are now open for questions. We'll start first in the room, and then we will go to the WhatsApp questions. Please remember to give us your name, and then you may ask your question. Okay, Abongile, Muloko, and my colleague there at the back, you may go ahead.
Good morning. Abongile, SABC. I want to Solicitor General, when you, well, I don't know if you said to solve the deadline that by the end of 6 months all these letters will be sorted out. How confident are you that you will meet the target deadline? How confident are you that you'll be able to squeeze in all these letters before the end of 6 months? Thank you.
Okay, Muloko.
Thank you. Muloko from ENCA. I have 2 easy questions. These 48 matters, if you can just verify, are these that you say are currently before court, are these matters that you couldn't agree on during the negotiations and they had to go to court to be settled? But second question related to that, as much as you are saying they are sub judice, but you would agree that matters that are before court, unless specifically stated that they must be sealed, those are public, are in the public domain. They are supposed to be known. So if you can just, without you compromising the case, if you can just tell us specifically what are those, what are the sticking points that led to a situation where this matter is now before court. And lastly, in terms of the money, how much today has the state paid in as far as this Marikana matter is concerned? And another final question, sorry. Oftentimes, it's the focus tends to be on the 34 who were killed by the state. We know that for a fact. This whole reparation, if you can just separate.
All right, that is the press briefing that is currently happening in Pretoria. Now, this is, of course, on the Marikana litigations, and this is basically just an update on the status so far, some of those claims that have been made, and this is, of course, the Department of Justice and Constitutional Development's update on the progress that has been made on Marikana-related litigations. As you can hear right now, it's the question and answer session with members of the media, of course, trying to also just put a with a fine comb go through
let me start with
how
the
these claims
question
will
by
be
Abongi.
addressed, and and when they will be addressed. And this is all currently happening right now in Pretoria.
Case managed. When matters are case managed, it means for a very long time the parties were not able to meet each other, and the court is disturbed by the delay in the finalization of the matter. The delays could be triggered by a number of issues, such as perhaps the unreasonableness by the state, or alternatively the unreasonableness by any of the claimants or representatives of the claimants. Under those circumstances, you require an umpire, and that is why matters are put before a dedicated a judge president who will then decide, more like give directives on the way forward in the handling of the matters. Because often when matters are sitting there, on the court roll, they clog the court roll. It makes the administration of justice also impossible, because you end up not knowing what you should be doing in relation to those matters. So all of the matters relating to Marikana, in line with what we reported last year, were all clustered under one, mainly because the representatives of those claimants are very few. I think you're talking about 3 firms of attorneys representing the whole lot. And on the other side, you've got the office of the state attorney. So it was very easy to manage, because if you appear before the judge president for one matter, automatically you would be appearing for all the other matters. So the issues are similar, the course of action is similar or the same, and therefore those matters, as I've already indicated, were judicially managed by the deputy JP of the court, designated court. Now, when they are judicially managed, it means the parties, through a pre-trial minute, are able to agree and forecast, if these matters were to run in court and evidence is led, how much time can they all be allocated? And when they are allocated, it's a block booking. In this instance, we could have started on the 9th of July, up to and including the date that I've mentioned in August. Because certain facts are the same, the only issue that remained to be dealt with was the quantum. There is no dispute about the course of action. So the quantum will differ from one claimant to another, based more particularly on the injuries that have been sustained and other attributes. And for that reason, some of the matters in the 48, I've given a ballpark figure that from where I sit now, I believe that almost 24 of those matters or half of those matters have settled as I stand right now. Meaning the few that are there, by the time that we finish this press conference, you could find that 12 or more might have settled. Now, that in fact goes to the issue of whether one needs to have any confidence with regards to the date. None of the parties, in fact, have set that date. That was imposed by the Deputy Judge President. Meaning, should it happen or occur to the court that the parties are not able to finalize the matters, further arrangements through a judicial management process could be directed by the Judge President upon request. So, if you are allocated time in court and you've got such few matters that are still remaining, and the issues to be determined by the court are very straightforward in the sense that you are only talking about quantum. Somebody is sitting at 100 rand, the other one is sitting at 75 rand. It is up to the parties to prevail and still try to find each other to say, can't we meet somewhere? But you don't do that with the latitude of saying, no one is actually looking at us. The Deputy Judge President is and continues to have a vested interest in those matters. That is why when we talk about judicially managed matters, you also have a deadline as to when you need to be dealing with these matters, because from time to time you need to go back and report whether you have reached settlement or not, whether any matter should be allocated to any of the judges or not. So that's the process that actually happens in court. I would not actually have any control over that process. It's an administrative process, but it is overseen by the most senior judge of the court that is in fact intended to hear those matters. Now, there is the issue that Mr. Muloto is raising from ENCA. It actually has a bearing on the answer that I've given partly to Abongile. You indicated that where we is it possible that these matters are sealed such that we cannot actually talk about the quantum? I've indicated that matters that are sub judice, like when I'm standing here and the court is doing something on the other side, I'm precluded from preposterously dealing with those matters. It is impermissible because the court is seized with those matters. But there is no way that we could actually give information to say these matters are in court now. I think your colleagues might also be in court as well, reporting on what is happening there. But from where I sit, I would rather leave the court to make a decision in relation to those matters. There are matters that, in fact, through the same process that I've indicated, offers have been accepted from the 48. And offer and acceptance is something that in fact happens between the parties, but we are certain that those matters are not going to serve in court. All that happens is that the client department that is responsible, that consumes or is actually held to be responsible, more particularly SAPS, would have to first effect the payment that has been agreed in court. But I think you will respect the fact that I do not want to be in contempt of the court process by in fact postulating into those matters and indicating quantum and related aspects related to those matters. Now, the other part of your question, in fact, relates to the quantum that, in fact, has been paid by the state. In my view, that would, in fact, be issues that I said were covered during our report last year. If you recall, in relation to those matters, we have indicated that apart from, personal injuries, special damages and related aspects, as at that stage, we had paid almost just under 76 million rand. Under 4 million rand has been paid to the University of the Witwatersrand, and the balance has been paid to SIRI, which is the Socio-Economic Rights Institute. That is in relation to the deceased members. The other category would be a matter that we settled after our press conference last year, also by way of a settlement. It didn't have to go to court. and we paid also there just under 3.5 million rand to one of the survivors, not one of the deceased. The rest of the matters are what is before court. If there is any other matter that is not part of those, we as the state have not received any claim. But I think I also need to emphasize that if we have not received any claim, what it means is that state attorneys are creatures of instructions. If we have not received any claim, we will not be able to entertain any such matter because it is not on our records. So what is on record now, what is before court, that which remains our focal point is the 48 matters that I'm referring to, which ought to have started by the 9th of July until the end of August, half of which I'm indicating we have been able to reach settlement. Half of which I'm indicating as we sit here, by the time that you get out of here, probably 12 or 15 might have settled, and the rest will have to, in fact, undergo the process that is judicial management, mainly because the parties might not be able to reach each other insofar as settlement is concerned. I think those are the questions that I was requested to respond to. Thank you.
We do have questions from the WhatsApp group, but you may...
Oh, okay. No, I can stand here.
Yes, my colleague
Yeah.
Ishmael will do them now.
Thank you, Chairperson. Thank you, the Solicitor General. We have 3 questions from Kauhelo Mahulefo, UFN. The first question, with President Cyril Ramaphosa being singled out for blame on the massacre, correctly or otherwise, how many of these police cases are against him specifically? The second question from Kauhelo, in the matters that you say have already...
That's the engagement that's currently happening there in Pretoria with the Solicitor General, Mr. Bandilani. Now, he's, of course, talking about those delays when it comes to settling the claims that are related to the Marikana massacre. He says that some of the delays are attributed to a clogged justice system and, of course, getting into greater details about the operational matters relating to addressing these claims. He says some of these claims, of course, relate to the same matter. He says indeed these claims relate to the same matter, but they need to be treated individually as they are. And he says about 24 matters now have been settled and more are still to be settled, or some of the settlements might be underway as, you know, they're speaking right now to the media, but stresses that matters should be settled or served by August 2022. Let's take you back to that engagement session. And of course, this is all happening at the back of some of those delays where you've seen some of the litigants have come through to say that their claims had not been settled and there had not really been clear communication as to what led to these delays. And of course, there, the Solicitor General, Mr. Bandilani, getting into greater details, you know, about what led to some of these delays. And he says that a clogged justice system, and he says that also making sure that all the details of the claimants are captured on the system on time, that was also something that led to some of the delays that we've seen, and went into greater detail as well about the finer detail about operational matters when it comes to settling these particular claims, and says that, you know, when it comes to addressing these particular claims, some of these claims you know, need to be treated as individually. Let's go back and listen in.
Might not actually get my thought processes. So rather let me answer a direct question.
No, I just wanted you to separate them. If these are two separate cases, they have nothing to do with these ongoing cases that are being managed through the process you are outlining. So that people can understand that.
Yes.
That's a matter that might have a different view depending on what the process.
Let me start with the last question, Remulot. The Office of the Solicitor General, and by extension, the offices of State Attorney, to which I am the executive officer, only deal with matters that, in fact, have been referred to them. In this instance, you can go back to my indication that we are creatures of instructions. We protect the interests of the state only in matters where the state has been cited as a respondent. So I cannot venture into matters that probably were serving before Judge Lamont or any other person, if the state in its name, either a government department or something, has not been cited in those matters. So, by extension, the matters that I'm referring to, and accepting that we are a creature of instructions, are those matters that were entrusted upon the state attorneys to defend for and on behalf of the state. It starts with the matters that I spoke about when I gave a report last year. The deceased, which was category A. Category B would have actually been matters where people claimed that they've been maliciously prosecuted, arrested, detained, and related aspects. Category C is personal injuries sustained as well as special damages arising from the incident. So that's specifically what we are dealing with. There are, however, other claims where the state is not involved. And by extension, the matters that we are dealing with do not, if ever existing, do not cover the matters that you are referring to, Khumuzo, which is in fact maybe matters that were preferred against the president in his person. I don't have a mandate to venture into that space because they never actually came to us as instructions. So we are dealing with matters where the state in its formation has been cited, whether it is matters that in fact the NPA or Minister of Justice and Correctional Services and SAPS were cited as organs of state or as state departments. So these are the matters that we are seized with. We are not seized with any matter that in fact is of a personal nature. So any expenditure that in fact we are spending for now relates to matters in protecting the interests of the state insofar as those respondents that are government are concerned. We also do have a policy that is called state legal funding. There's never been any request by the president to be funded in relation to any other matter or for the services of state attorneys to be extended to him. And so that is the reach that I will never be able to venture into because it is not in our space. And those questions would naturally belong elsewhere as opposed to matters that we are dealing with as at the moment. So that is just to deal with the issue that Mr. Mloto and yourself are raising. There were three issues that Khaukhelo Makhuleko raised. And I think partly I've dealt with that issue because the first question was whether the president who has been singled out is part of these matters that we are talking about. No. None of the matters have got the president cited. Whether it is matters that we have settled relating to loss of support for those that passed on, or alternatively the matters that we dealt with against perhaps malicious prosecutions, and by extension, neither is the president's name mentioned in the 48 matters that I'm talking about now. And so that question also falls within the category of my reply when I gave Mr. Mloto the reply. The second question is that I need to explain the things that have been considered. Now, delict has got two elements to it. And the two elements arise from causation. And causation goes into merits of the matter. So there is no contestation or dispute about causation and the merits before court as we speak now. Now, causation and merits would relate to an issue where the state is disputing whether any of the claimants has been injured in Marikana. We are not in court for that reason. That has long been considered. So there is agreement that indeed all of the 48 are eligible to receive some form of compensation. Now, the last leg to a delictual element which deals with matters of this nature is quantum. Now, quantum talks about the rands and cents. It talks about the money that is fair and reasonable under the circumstances to compensate one person. But when we talk about quantum, we further divide it into two, which is general damages, which is personal pain and suffering of the person, as well as special damages. Special damages would relate to loss of income by somebody that is still alive, as well as income or as well as expenses that that particular person might have had to pay for medical bills, medical expenses, private medical care, and related aspects. So if we drill it down to quantum, the state has considered on production of proof that all special damages are payable. We don't have a problem with that. However, when it comes to general damages, that is where we couldn't reach each other. So the issues have been narrowed down to general damages, pain and suffering. What is the extent of the pain and suffering that this particular person has suffered? So one might be sitting at 6 million rand, for example, and the state is sitting at 1 million rand. Now the principles of delict are very, intricate. And because they are intricate, they sometimes require experts. And this is not something that, in fact, I need to, project here as forming a part of this report. This is something that is best left for experts. You sometimes need medico-legal report. You also sometimes need actuarial reports. And these are the issues that the teams are dealing with. So if we were to narrow it down and say, why are we in court? We are in court not on the merits. We are also not in court, not on the issue of quantum, holistically understood. We are in court not on special damages, because we have said on receipt of documentary proof, the state is willing to pay any special damages that have been incurred. We are in court only on the limited aspect, which is general damages. I've got my ear cut off, maybe, or something happened to me. I think I'm entitled to X amount. And the state says, we will pay you Y amount. And there is no agreement between the parties. And that is what, in fact, the court is zooming into, to say, why can't you, in fact, agree on these specific item, given the fact that you're almost there. However, we are creatures of instructions. We look at what is possible, and with our advisories, we are told that perhaps this matter should be settled at Y, the other one is asking for Z. So we will be able to find each other one way or the other, because, in each and every 1 rand there is a cent. All that needs to happen is to narrow the gap between the state and the claimants. There is a question that says, how much has it cost the state so far in defending the matters? I think that is one issue that gives me nightmare, because simultaneous with us coming up with the policy, which is early settlement, one of the rationale for doing that was so that we can, in fact, in all instances, limit the exposure by the state in defending matters of this nature. I do not have, and we have not calculated that figure for the purposes of this press briefing. I never anticipated that it will be something that is of interest, but I think via GCIS you could actually get that information once the information has been collated. As I stand right now, I think it will be misleading for me to try and venture into how much we have paid, which is own costs, by the way, because the figures that we are in fact paying by way of settlement, in the majority of cases, they also include the costs in there. So it is easy to calculate what we are paying to the other side. But when the question in fact is, how much are you paying for defending the state? It is an issue that I think in the interest of this interview, we will have to in fact ask the GCIS to get the feedback from the Office of the State Attorney Pretoria, which is where all matters relating to Marikana are centralized. Thank you.
one question from the WhatsApp group. I just wanted to know from the colleagues in the room, is there any other last question?
Yeah, my question was not answered, and I guess I can add the question on the 10 who were killed before the 34, and maybe to add and say, are the families of the 10 who were killed perhaps also part of this litigation or matter that?
Now, it's still that question and answer session there happening with the Solicitor General in Pretoria, Mr. Pandelani, of course, giving a status update on the Marikana litigations, going into details about the different categories that the claims have been addressed. And he says they're dealing with matters where SAPS as well as other bodies were cited, and says these need to be handled with sensitivity. He says that indeed all the 14 claims were, 14 claimants were eligible to receive a settlement, and this is not in dispute, and says they would now have to iron out what now becomes a fair and just compensation. He could not really venture or be drawn into the exact amount that has been settled thus far. Let's take you back there.
There are two critical mandates that in fact reside with the Ministry of Justice and Correctional Services. One of the mandates is to oversee the work of the National Prosecuting Authority, whilst the other one is to oversee the work of the Solicitor General. Now, those two components deal with different matters. Justice in its broader description is very abstract. But if it's criminal justice that we are referring to, I would not be able to deal with those issues because those issues reside with the NDP and DPP. Whether anybody has been prosecuted, not prosecuted, and I would not be able to venture into. Even if I had that knowledge, I do not have the statutory mandate to talk about justice in that sense. The justice that I'm talking about is reparation in the civil context, which is compensation. Litigation is within the space of the Office of the Solicitor General. And when we say the Solicitor General is the executive officer of all 13 offices of state attorney, what it means is that you give strategic direction to those offices, but you only deal with litigation as it is commonly understood. The only time that you would actually be nearer any criminal matter is when you are representing any government official that has been arrested for some infractions that were in fact conducted within the course and scope of their employment. However, prosecution is something that I will never be able to deal with. So the process that in fact we are involved in, starting with last year and this year, resonate with access to justice from a reparations point of view relating to litigation of the matters. And so to answer the question from Mariska, yes, I think I'm comfortable that justice has been done in relation to reparations relating to litigation matters or litigious matters, to the extent that those matters served under the auspices of the state attorney. And so that is in part my answer. Remlot, I think let's disambiguate, because we might actually confuse a lot of people. Are you talking about the police that were killed? Security and against the state? I think I will allow Mr. Chowe to answer that, but to the extent necessary, no. Not to us, but remember there are parallel processes that are going on. One of which you in fact alluded to, and I said I don't have instructions to deal with. The other being that the mine itself might have actually received other claims. We can only talk about the impact on the fiscus, the matters that we have received. And if we have not received any matter by now, 10 years down the line, you know as much as I do that that matter would have already prescribed because of the prescription period, unless if perhaps the claimant is a minor. But I think let me leave the other part for my colleague who is in fact overseeing the unit that is dealing with the Marikana matters to talk about on the 10 matters. I know that I've given you part of an answer, but I need you to have a holistic answer in relation to that. Thank you.
Thank you, Solicitor General. And maybe I must just be honest enough and say I would like to defer the question on the 10 matters, maybe for a later response, because all these matters, as they served before the state attorney, there might be names which are mentioned in some of these pleadings and not necessarily captured as specifically so and so and so and so. So as I speak, the attorney who's handling the matters, unfortunately, he couldn't make it to this press conference. But I would, through yourself, SG, defer your question so that we can have a more prompt response, and which is not doubtful at all, if I might leave it there. Thank you.
Thank you all. This brings us to the close of this media briefing. Thank you, Solicitor General and the colleagues. Thank you very much. Colleagues, are there any one-on-ones you want to do?
Okay, we come out of that media briefing now. This was, of course, the engagement session that was happening with members of the media, as well as the Solicitor General, Mr. Pandilani, of course, giving a status update on the Marikana litigations. They're going into details about the different categories that the claims are being addressed. And, of course, he spoke about how they're dealing with these matters, as well as the various delays that were in this particular matter.